This project is about Edward White and the District of Columbia versus Heller case. Edward Douglas White was born November 3, 1845, near Thibodaux, Louisiana. His father, Edward White, was a judge, congressman, and governor of Louisiana, and his mother was Catherine Ringgold.
Edward had a Roman Catholic Jesuit education at Mount St. Mary's College in Emmitsburg, Maryland. He fought for a short amount of time in the Civil War in the Confederate Army. After the war, he began law education in New Orleans, where he established a successful practice.
In 1874, he was elected as a state senator and appointed to the state Supreme Court in 1878. His political position was Democratic. Eventually, he was elected to the U.S. Supreme Court by President Grover Cleveland in 1894.
As Associate Justice, he formulated incorporation of territories which were acquired by the United States in 1898 in the Spanish-American War. Edward was promoted to the Chief Justice by President William Howard Taft in 1910.
Wilson versus New sustained the Adamson Act of 1916, fixing minimum wages and maximum hours for railroad workers. Arbor versus United States. Military conscription was upheld in this selective draft law case.
Edward was of Irish descent, raised Roman Catholic, and his father was a sugar plantation owner. Dick Anthony Heller was a D.C. Special Police officer who sued the District of Columbia in this case. Justice Antonin Scalia delivered the court's opinion and was joined by Chief Justice John Roberts, Jr., and Justices Anthony Kennedy, Clarence Thomas, and Samuel Alito. Junior Justices John Paul Stevens, David Scouter, Ruth Bader Ginsburg, and Stephen Breyer.
District of Columbia versus Heller happened on June 26, 2008 in the Supreme Court.
District of Columbia versus Heller originated in a suit filed in the U.S. District Court in Washington, D.C. in 2003. In Parker versus District of Columbia, 6 residents asked the court to enjoin enforcement of 3 provisions of the district's Firearms Control Regulation Act that generally prohibited the carrying of unlicensed handguns or any other deadly or dangerous weapons. The district court granted the government's motion to dismiss.
Provisions of the District of Columbia Code made it illegal to carry an unregistered firearm. The code also contained provisions that required owners of lawfully registered firearms to keep them unloaded unless the firearms were located in a place of business. Dick Anthony Heller was a D.C. police officer who was authorized to carry a handgun while on duty. He applied for 1-year license for a handgun he wished to keep at home, but his application was denied. Heller sued the District of Columbia. He argued that they violated his Second Amendment right to keep a functional firearm in his home without a license. The district court dismissed the complaint. Then the U.S. Court of Appeals for the District of Columbia Circuit reversed and held that the Second Amendment protects the rights to keep firearms in the home for the purpose of self-defense.
Heller argued that for any other guns he owns, he should be able to keep them in ready position in the house. Heller said the Second Amendment does not allow the district to place those restrictions on this right to bear arms. He sought an injunction against the enforcement of the relevant parts of the code and argued that they violated his Second Amendment right to keep a functional firearm in his home without a license.
The Supreme Court sided with Heller by a 5-4 majority, affirming the appeals court's decision. The court ruled that the District of Columbia must give Heller a license to possess a handgun inside his home. In the process, the court ruled that the Second Amendment protects an individual's right to bear arms and that the district's handgun ban and trigger lock requirement violated the Second Amendment. The court's decision did not prohibit many existing federal limitations to gun ownership, and it didn't affect limitations preventing the possession of firearms in schools and government buildings.
Courts are reinforcing that gun safety laws are not only constitutional, but that they are critical to keeping our communities safe and protecting other constitutional rights, like the freedom to safely assemble in public without fear of gun violence. Since DC versus Heller, lower courts have upheld a wide range of gun laws as constitutional, including firearm design safety standards, safe storage requirements, waiting period laws, private sale background checks, and licensing laws.